Thank you, Gilly, for that introduction, and I'd like to compliment you on how well you have framed the issue concerning permit retirements. I'm going to talk about a model of permit retirement that I've been working with for the past several years with the Grand Canyon Trust. But first I'd like to sort of contrast that to a more traditional method that I've also been involved with for the Nature Conservancy, and actually how I got started in this business. I'm a private attorney in Salt Lake City, and about 6 years ago I was contacted by the Nature Conservancy to help them out in some litigation. This is the Nature Conservancy of Utah, who had just purchased a couple of large public land ranches in the Book Cliffs area of northeastern Utah, and had been challenged in court over their qualifications to hold the grazing permits associated with those ranches. The Nature Conservancy had essentially adopted this more traditional method of buying the ranch, buying the permits along with the ranch, and then negotiating with the agency, in this case it was the BLM, concerning grazing reductions or grazing elimination on the respective allotments. And there are certain advantages to this approach. Probably the three most significant ones are, number one, owning the ranch, or what's known as the base property, gives you better control over the grazing permits. Number two, that owning the base property allows you to protect the private land associated with the ranch as well as the public land, and it certainly eliminates the threat that once the private land is cut off from the economic support that it has traditionally received from public lands surrounding, that it won't immediately turn into condominiums or some other type of undesirable development. And now that the U.S. Supreme Court has decided that you don't have to be, quote, in the livestock business in order to own a ranch and the associated grazing permits, this has certainly removed one of the major obstacles for private groups to get into this type of business. So those are the advantages, but there's one big disadvantage, and that is it's very expensive. Buying a 1,000-acre base property ranch will probably cost you $1 million or more. And if it's a scenic piece of property, it's going to cost you a lot more than that. Buying the grazing privileges on the same 1,000-acre parcel, if it happened to be public land, will cost you just a few $1,000s. So groups that don't have a lot of money, like the Nature Conservancy, want to know how can they buy out just the permit. And that's really what I want to talk to you about today. It would be nice to think that in our free market economy that someone who believed that they had a use for the public lands that was higher and better than grazing use could simply come forward and make a bid on the grazing permit, or approach the party that holds the grazing permit and offer to buy them out and put the land to this higher and better use, particularly where it involves less damage to the resource. For example, if you're an outfitter or you own a bed and breakfast next to a canyon that has a BLM grazing permit on it, and you can show that you can earn more money from your clientele or through your business by not having cows in that canyon than somebody else can by running livestock, why shouldn't you be able to go to the permittee and say, hey, I can offer you more than this is worth to you to buy out your permit, and then I can put this land to a better and higher use? Well, unfortunately, we all know that it doesn't work that way, that the free market rules do not apply to public lands grazing. And I won't go into the reasons for why that is. That would be the topic of a whole nother talk. But basically it's because the Taylor Grazing Act and the Bureau of Land Management require that anyone who holds a grazing permit satisfy certain mandatory qualifications. First of all, you have to be a citizen of the United States, either that or a company that's doing business in the state where the grazing allotment is located. You have to own the base property, and that base property has to be capable of sustaining a grazing operation on the allotment in question. So the fact that you might own a bed and breakfast that's located next to the canyon doesn't really get you what you need. And although you don't have to be in the livestock business anymore, you do have to be a stock owner or an owner of livestock. And then even if you somehow manage to meet these mandatory qualifications, you can't just buy the permit and sit on it. Failure to make substantial use of a grazing permit as authorized in the permit is grounds for revocation. And if your permit is revoked, it will be reissued to someone else at no charge to that person, and you will have lost your investment in that permit completely. So the question is, how does a conservation group that wants to buy out a grazing permit get around this problem? Well, the answer, or at least one answer that I have found, is in the type of transaction that I've helped the Grand Canyon Trust put together on about 5 or 6 different occasions involving grazing properties in southern Utah, most of which are located in what is now the Grand Staircase-Escalante National Monument. But it's important to understand that this particular transaction only works in certain situations. First of all, it will only work where the rancher is willing to sell or to give up the grazing permit without also selling the ranch. And that's not always the case, because a lot of times the rancher is going to want it to be a package deal. But if you can find a rancher who's willing just to give up the permit, you also need to find a situation where the BLM is ready and willing to go forward with eliminating grazing or reducing the grazing on the allotment in question. And the only reason that they haven't done so already is basically out of concern for the economic consequences to the permittee. Now, if both of those conditions are present, here's what you can do. Basically, what you do is you pay the rancher the market value of the grazing permit in return for 2 things. Number 1, the rancher's agreement to surrender the permit back to the BLM, and secondly, the BLM's management decision to retire the permit and the underlying AUMs. Now, this is a pretty simple concept, of course, but the mechanics of implementing it are a little bit tricky, and it's primarily because you as a conservation group cannot buy the permit, you cannot control the permit, you can't even hold it temporarily. And so we have to come up with a sort of an artificial structure of an agreement to accomplish what we're trying to do. And let me kind of just walk you through that, just so you understand how it works. First, you set up a 2-way agreement between the conservation group and the rancher. The BLM is not a party to this agreement. It's important to remember. The BLM is not, will not, cannot be a party to this agreement. The rancher agrees to offer to the BLM to relinquish his or her grazing privileges. The conservation group agrees that if the BLM accepts that offer and if it amends the land use plan to retire the AUMs and eliminate grazing use on the allotment, then and only then will the group pay the rancher the agreed upon sum, and that's typically the appraised value or the agreed fair market value of the grazing privileges alone, without the base property. Now, even though the BLM is not a party to this agreement, you can't forget about their role. Its action, the action of accepting the relinquishment of the grazing privileges and amending the land use plan, has to be structured in the agreement as what lawyers call a condition precedent. And essentially, that's something that has to happen before the group's obligation to pay the money is triggered. And if for some reason the BLM doesn't follow through with the amendment to the land use plan to eliminate grazing, then the deal doesn't close, the rancher keeps the permit, and the conservation group keeps its money. Now, there are a couple of important things to remember about this type of transaction. First of all, you got to assume it's going to take 6 months or probably more, maybe a year, for the BLM to complete all of the administrative actions that are necessary to eliminate grazing. And that's assuming that they're really willing and ready to go. They're just waiting for this transaction to come into place, and they will leap into action immediately. It's still going to take 6 months to a year. And so you've got to explain this to the rancher. The rancher probably already knows about how long it takes the BLM to do these type of things, but it needs to be made clear, and the rancher has to be willing to wait to get the money until all of that has happened. If the BLM, for whatever reason, is not actively engaged, no rancher, I don't think, or not very many, are going to want to wait around having their permit tied up under this agreement while everyone tries to figure out how to get the BLM motivated to do this land use plan amendment. The most that you can ask from the BLM in terms of what decisions it makes in terms of implementing this agreement. Essentially, they make a management decision. But you've got to remember, and it's very important that nobody deceives themselves about this, whatever the BLM decides to eliminate today, it can decide to restore tomorrow. And there is no way you can tie their hands otherwise. That's why you wait for their decision to accept the relinquishment and to eliminate the AUMs before you close the deal, because you don't even know for sure if they're going to do that. But once you clear that hurdle, how do you minimize the long-term risk that there might be some future management decision to reverse what you have relied upon in closing your agreement? Well, I don't have any magical answers for you on this. It really comes down to a question of political judgment. First of all, you have to pick the places where you're trying to do these deals. You have to make a judgment that essentially if you can get the cows out of there, the situation is such that they will never go back. Most of the Grand Canyon Trust deals that I've worked on have involved the Grand Staircase-Escalante National Monument. There have been a few other what we would call special situations. But basically, my advice to you would be, don't do this unless you believe that the agency, and I want to emphasize, the agency has concluded that grazing is no longer appropriate. Whether you as a conservation group have reached that conclusion, and obviously you have, the fact that you might have reached that conclusion really doesn't matter. It's what the agency thinks. Now, they're not going to come out, probably, and publicly state that grazing is no longer appropriate on this particular allotment because, well, basically to do that, they're essentially admitting that they've been wrong all these years about allowing grazing to occur on the first place. The way they will sort of officially explain their position is that, well, we're going to reallocate the forage to wildlife. And that's really what's happened in the situations that I've been involved in. And it's not really a very satisfactory response and there are really two reasons that it bothers me. Number one, if the forage that's been reallocated to wildlife is not utilized by the wildlife, it sort of leaves the BLM open to a claim that they should allow someone else to come in and utilize it. And I think it's certainly a matter of concern that we're kind of leaving the door open just a little bit to that possibility that we all worry about, that the rug might get pulled out from under us 5 or 10 years down the road, and all this money we spent retiring these permits has been wasted. I just want everybody to recognize that that's a concern. So it underscores the importance of looking into the agency, talking to the people, having close contact, knowing the people you're dealing with. They'll tell you privately whether they think the area is appropriate for grazing or not, and that's what you really have to base your decision on. If you feel like the agency really wants to do this, they really mean it, and they really mean it in the long run, then go ahead. If you have any doubts, I would say don't try it. At best, you'll spend a lot of time putting this deal together. You'll probably have administrative costs, and you might even find out that it doesn't even close because everybody gets cold feet at the end. At worst, no one gets cold feet, the deal closes, and 5 years later, the cows are back on the allotment, and you've got no way to recoup the thousands of dollars you've spent to try to get them off. A lot of people ask, how do we know what these grazing permits are worth? How do we value them? How do you appraise those? Because that's essentially what we're trying to deal in here. The ranchers know what they think they're worth. And a lot of times they have a pretty good idea, and it's pretty accurate. If you talk to an appraiser or an economist, they'll tell you there's two ways to come at it. Regardless of how you do it, you're looking for comparables, just like you're appraising a home or a piece of real estate. You're looking for similar pieces of property that have been traded under similar conditions. So if you can find an instance, for example, where similar AUMs on similar type land have been transferred from one base property to another, and you can find out how much was paid for that, that would be pretty good evidence that that's what the ranchers, and that's how they value, that's what they're willing to pay for these grazing privileges. Another way to come at it would be to have more formal traditional appraisal done of the base property itself with the grazing privileges, and then appraise the same property without. It's kind of like just doing a business appraisal, and then the difference would be the value of the grazing privileges. And of course the best approach of all would be to take both of those, if you had evidence of both, put them together and saw that they came out about the same. That would tell you you've got a pretty good fix on what those grazing privileges are worth. It's important to stick to market value, especially if you're a conservation group that's soliciting donations from people who want to get an income tax deduction for the money that they're giving you. You want to be able to show that you're not using those same funds to enrich or give a windfall to some private interest. You're paying strictly market value for a public purpose. That'll take care of your donors. It's also just a good way to do business. I'll just wrap it up really quickly. There are a few other technical points I could cover on how we structure these agreements. If anybody's interested, you feel free to give me a call or send me an email. I have a form that I use for these things that I sort of start with. Every deal is a little bit different, so you just can't fill in the blanks, but I was actually tempted to sort of bring a copy of it here and leave it for everybody to look at, but I haven't. I've been meaning to get around to writing up a user's manual to go along with this thing, because I sort of feel like it might be a little negligent to just throw this thing out without some kind of explanation on how to use it. So I would sort of say this: if anybody wants it, give me a call. I'd be happy to send you a copy, email it to you, fax it to you, and answer any questions about how it can be used. But I would just caution you, don't try to take it and just fill in the blanks, because there are a lot of little pitfalls that could cause trouble. To wrap it up, so far we've done 5 or 6 of these transactions. So far they've all worked. Each time we've put down earnest money, the trust has been able to raise the private funds necessary to do the complete buyout, and in each time we've come up with the money, BLM has gone forward and done the planning amendments necessary to close the deal. The ranchers have been paid off. They've always honored their agreements to surrender the privileges and to remove the cattle. So far, it's worked out pretty well. Obviously, we haven't been doing this but for a few years, and so the long-term questions still remain. It's probably too early to tell how these things are going to hold up in the long run. We probably get our first test if we have a new administration. It'll be interesting to see. So far, it's too early to tell what happens to the base properties once the grazing privileges have been severed. It's not like we've seen a rash of development on these private properties. In the cases we've worked on, most often the ranchers have remained in the livestock business and have simply gone elsewhere for their grazing privileges. But we're keeping an eye on the situation, and hopefully it will continue to work out. Thanks very much.